Hello, my name is Mason Wager, and today I'll be presenting the Supreme Court case Abington School District versus Shemp that was decided in 1963. This landmark case addressed the constitutionality of Bible readings in public schools and was a crucial and foundational decision in defining the relationship between religion and public education under the First Amendment.
And I'm Matthew Young. I'm the other partner in this group case. So the parties involved in this case is going to be first the petitioner, which is the Abington School District, which is in Pennsylvania. And the respondents are the Shemp family, which was led by Edward Shemp. And a little background about the Shemp family is that they are a Unitarian family who objected their children being exposed to religious exercises in the public schools. So this would be the reading of the Bible that was a state requirement in Pennsylvania at the time. And so Edward Shemp and his wife filed the suit on behalf of their children, and their argument was that that law violated their religious freedom and the separation of church and state.
So now we would be going over the facts of the case, especially the crucial ones. So for context, in Abington Township, Pennsylvania, Pennsylvania state law requires that at least 10 verses from the Bible be read aloud at the start of each school day, and then followed up by the recitation of the Lord's Prayer. So that is our first thing that gives us context leading into the issue. The issue was that while participation was technically optional because students could be excused with a written note from their parents, Edward Shemp argued that this placed indirect pressure on students to conform to a religious practice and a specific religion itself, that the practice itself was a government endorsement of that religion. This caused Shemp to go and take action. Shemp then brought the case to court, getting a lawyer, and claimed that the Bible readings and prayer constituted a religious exercise conducted by a public institution, which then violated the Establishment Clause of the First Amendment. And we then see during the legal process, the case makes its way all the way up to the Supreme Court, where it gets taken by the Supreme Court, and it was decided alongside another similar case from Baltimore involving a mother and her child, where we see Murray versus Curlett.
The central legal issue in this case was the mandatory reading of the Bible verses. And this was Shemp's defense in him saying that these readings were in violation of the Establishment Clause of the First Amendment. And that prohibited the government from establishing or favoring any religion. This was mainly an issue because this reading of the Bible and the reciting of the verses was happening in a state-mandated and government-run setting. And so for the Shemps, because of their beliefs, and they did not believe in the literal interpretations of the Bible, when their children were being exposed to things like the New Testament, and for that particular religion, that's not what they believed, he felt like that was in violation of their rights, pretty much. And even if this was an optional practice, by having the children step out every morning, they would start to be alienated from the other children as they knew that they were different, and this would affect the social lives of their children. And that's why the Shemps felt so strongly against this.
So to continue with the legal issues from this case, the Establishment Clause says that Congress shall make no law respecting an establishment of religion. And over time, they've interpreted this to mean that government institutions, including public schools, cannot promote, endorse, or favor any religion in specific. So in this case, the Supreme Court had to decide whether having students read from the Bible each morning, regardless of whether they could opt out or not, that doesn't play a part, still amounted to government-sponsored religious activity. The court had already ruled in another big case, Engel versus Vitale, in 1962, that a state-written prayer in public schools was unconstitutional. So they already had this going into it. But then the main question was whether reading from the Bible, even without commentary, and even if students could be excused, also violated that same principle. So the justices looked at whether the purpose of and the effect of the law were religious in nature, and then they convened and concluded that the Bible readings were clearly acts of worship and religious devotion, not neutral moral instruction. Supreme Court Justice Tom Clark wrote for the majority, stating that the readings and recitations were religious exercises and that the state had no business organizing or endorsing such exercises in public school. So the court then went on to rule 8-1 that the practice was unconstitutional. It concluded that Bible readings were indeed a religious exercise and that the government, through the public school system as a part, cannot promote or endorse religious practices, even if participation is voluntary and can be opted out of. So this was a massive case and a massive decision that held obviously long-term implications, and it really helped solidify the principle that public schools must remain religiously neutral, and it reinforced the wall of separation between church and state massively. So it was definitely a big case and continues to hold influence in our world today.
So we both came to different concluding opinions on this case. For me, I did not personally agree with the court's decision. This is because I believe that the Bible reading is a part of America's moral and cultural heritage, and that the reading of the Bible is not trying to state a specific religion or kind of indoctrinate kids to believe certain things. It's trying to promote shared values that this country is based on, and there's some really good shared values that all children could benefit from, values like the golden rule and thou shalt not steal, thou shalt honor your father and mother. And it was also an optional thing. So if the Shemps really did have an issue with them participating and they did not want their kids to be exposed to that, they could have them step out of the classroom if it was really that much of an issue to them. And I also think there was a little bit of an overreach by the judicial system, and this was because I don't think they should have been pushing this much into local education policy. I still think that's a state right and should have stayed a state right, and I don't think there is a need to have this much attention put onto a local education policy.
So now that Matthew has shared his opinion on the case, I'm going to offer mine. I personally agree with the court's decision to continue to further establish the separation of church and state. Even though I am a Christian myself, and I do hold that very dearly and strongly in my life, and I would love if we could realistically see more God in our society and more believers in the U.S., especially in our school systems. But I don't believe that opening the door to government interference and state-run organizations pushing specific religions is a good idea. It feels like a pitfall that should be very easy to avoid in practicality. We just don't open that door, and I think that it could lead to long-term ramifications and issues in our society and between religions on a daily basis, and we don't want to have that in our school system. Thank you for watching.
Thank you for watching.
It's the law.